With that, I will formally call the first case. That is case number 118448, State of Kansas v. Howard R. Pruitt.
May it please the court, Peter Meharry for Howard Pruitt. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case is a case out of El Dorado in which my client was charged and convicted of first-degree premeditated murder. He was ultimately sentenced to a term of life with a minimum of 25 years before parole eligibility. That charge and conviction arose out of an incident that occurred in the late evening, early morning hours of August 1st and August 2nd of 2016. El Dorado police were responding to a call of a shooting, and they found an individual by the name of Philip Little who was deceased and was killed by gunshot. Eventually, the state charged my client with that charge and ultimately brought it to trial, and as I said before, convicted him. We've raised several issues on appeal, and what I'd like to do is start with the first issue that we've raised, and that deals with prosecutorial error, dealing with several comments the state made during closing arguments. And the first comment that we believe is problematic in this case is when the state gave its personal opinion with regard to the gun. At issue in this case was whether or not the gun they presented at trial was the gun that my client had or that was the murder weapon. There was varying testimony as to the description of the gun. One witness testified that it was a double-barrel shotgun. The gun admitted at trial was a single-barrel shotgun. There was varying testimony as to the description of the gun as far as its coloring and whether or not it was a pistol grip or a regular shotgun. But despite that, during closing argument, the prosecutor stated that, and this comes from volume 13, page 125, "This seems to be the shotgun, folks. I don't think there's a lot of questions about that at this point." A couple paragraphs later, the prosecutor reiterated, "So if identification of the gun is an issue, I think that's been resolved." And the problem we see with those comments is that the prosecutor is giving its personal opinion when it is saying, "I think this is the gun. I think any questions regarding the gun have been resolved in this case." And this court has said that prosecutors giving personal opinions is improper. It goes beyond simply arguing the evidence. It goes to the prosecutor's personal opinions about that evidence, which is not evidence in and of itself. And this court has said when the prosecutor states their personal opinion, that is a form of unsworn, unchecked testimony.
Let me tell you what's been bothering me about this, which is when a prosecutor, you would agree, we would all agree that prosecutors are able to outline to the jury all of the evidence that supports an element of the case, right?
Yes.
And isn't it really implicit that, sort of the phrase, "I think," goes along with, here are the things we proved to demonstrate element X, Y, or Z? Without saying "I think," it seems like it's always there anyway.
Well, I think the problem is that when a prosecutor says, "I think," they go beyond saying, "This is the evidence we've shown you, this establishes whatever." It's a stamp of the personal opinion of the prosecutor. This is the gun. Don't worry about varying testimony in this case. We've got the right gun, and this is it. And I think when the prosecutor says that, it goes beyond just saying, "This is what the evidence shows."
Mr. Meharry, I have a question about what the record tells us. There was some ballistics evidence, wasn't there?
There was testimony that I believe the shotgun shells that were found in my client's car were the same variety as what was found at the scene, I believe. And I think the testimony was that firearms expert that the pellets were consistent, I believe was the testimony.
But that was the extent of it? There was no firing tests or anything like that?
I thought there was firing tests to get to that opinion. I could be wrong on that, but I thought they did
Okay.
firing tests and then compared and said these are consistent.
So the particular comments you're pointing to at this time, on this particular aspect of your prosecutorial error argument, all have to do with the gun, and they're not tied, in your view, to that ballistics evidence in particular?
I don't see it as tied to the ballistic evidence.
Okay.
What I see is prosecutor specifically using the phrase, "I think," only relating to the gun and only saying, "I think any questions resolved with regard to the gun are done."
In
So
this
with-
case, no, excuse me, go ahead.
If we would assume with us, if we would agree with you that there was error in this regard, given the ballistics evidence, how can this be harmful in any way to your client?
I think it is harmful because a couple reasons. My understanding with regard to the ballistic evidence was that it was consistent. It wasn't like DNA where you got a match and your odds are 1 in quadrillion or whatever numbers they come up with. But it was simply consistent, i.e. it was the same type of ammunition. The other thing I think is particularly prejudicial with regard to the gun is I think the state used this as strong evidence, or they argued it was strong evidence, to tie my client to this gun. And by saying, "I think any questions regarding the gun are resolved," it undercuts any argument that the state hasn't proved their case. It undercuts the argument that, look, we have varying testimony with regard to the gun as to what gun it was. Was it a double barrel? Was it a single barrel? Witnesses stated different things. But they needed to show, the state needed to show, that that was the gun that my client bought from a third party. And with the varying testimony, that's in doubt. But if the state gets up there and says, "I think that's all resolved, and this is the gun, and this is the gun my client had and bought from this third party," then I think it undercuts my client's ability to challenge that evidence.
Let's go to the second part of the prosecutorial error equation, and that is, put simply, so what? One of the things we look at, obviously, is to how is this prejudicial, to go back to Justice Lukert's question, when your client admitted to, I think, at least 2 people that he killed the victim.
Well-
And the victim died of a gunshot wound, not just a gunshot wound, but a shotgun wound rendered by a .410 shotgun, which shot triple-aught buckshot.
As far as the testimony implicating my client, I would point out the fact that the witnesses who testified to that at trial changed their story multiple times throughout the investigation. One of the witnesses who implicated my client, the witness was Nathan Coe, who eyewitness testimony at trial. He said, "I saw Howard Pruitt shoot the victim." First time the police talked to him, he said, "I don't know anything."
Right.
Second
That's
time,
that's
he
a
changed his
jury-
story.
Excuse me, that's a jury call, though, counsel.
That
He-
is.
He gave varying stories, all of that went in front of the jury, right? And same for the other witnesses whose testimony you call into question. All of that was in front of the jury could weigh it all, right?
That was all in front of the jury, but I think that gets undercut when you have the prosecutor giving his opinion, stating that this evidence is resolved. There's no question about this evidence. I'm telling you, this is the gun. And I think that undercuts any defense my client has to question those witnesses who gave varying testimony throughout the trial, throughout the investigation. Multiple witnesses changed their story 180 degrees to implicate my client after multiple interrogations by the police. And I think that, like I said before, gets undercut if you can't challenge that, and if you can't challenge the gun when the prosecutor gets up there and says, "This is the gun. I think this is the gun. I think all questions regarding the gun are resolved."
If you don't mind, I'd like to jump you up to the, your claim about a juror being asleep
Okay.
during part of the trial, because I'm keeping an eye on the clock.
Sure.
and, on that. Explain to me how you think you made your case when you only have the one witness who's the daughter of the defendant, and the district court heard the evidence, heard the testimony about whether a juror was asleep or not, and nobody could identify the juror, and nothing was done at the time. It was 6 months after the fact. It seems to me it's difficult under those circumstances to question what the district court did under the circumstances when it wasn't contemporaneously brought up during trial.
Well, as far as, I guess, the problems we see with the district court's decision is that there was explicit testimony that there was a juror sleeping during parts of the trial. Secondly, the court...
From the one witness.
From the one witness.
But then there are other people that said, not so much.
Well, I would say the other people, including the district court, including, I believe, the bailiff, said they didn't see it. I don't think that's necessarily contradictory to the witness who said she was sleeping. Additionally, the court reporter also said that she saw one of the jurors nodding off at points too. So I think you have more than just one juror, or excuse me, one witness saying a juror was sleeping during trial, but I also think you have that explicit testimony stating that the juror was sleeping through substantial parts of this trial. So I think the evidence is there to make that finding, and I think the district court should not have ignored that evidence, particularly when there was no contradictory evidence out there. So
What's our standard of review in looking at this question? What's our test as to whether the district court erred in the ruling that it gave?
Well, generally speaking, I think the state has argued it's abuse of discretion as far as they equate it to essentially a motion for a mistrial. I think it seems to me somewhat of you have almost an evidentiary question, but then a question of law after that. And it seems most of the time when this court looks at issues that have kind of a question of facts and then a question of law, they apply substantial competent evidence standard to see if there is substantial competent evidence to support the district judge's decision. And I think here you don't really have that because the substantial competent evidence, I would argue, shows that there was a juror sleeping during this trial. And if you have that, I think that is certainly problematic and violates my client's constitutional rights to a jury trial, to have a jury of 12 decide his fate when one of them was sleeping through substantial portions of that trial.
I think the court reporter's statement, according to the record, is that a juror was looking like he or she was nodding off at the beginning of the trial, the judge was alerted, and then thereafter it didn't reoccur. I think the only person who said there was more than one incident is the one woman who testified, the daughter. Isn't that correct?
I think that's, if I said something, I think that's correct.
Okay, all right. Yeah, I thought you said substantial portions for both witnesses, and I didn't think the court reporter supported that.
No, my understanding, the court reporter said she saw someone nodding off early in trial. It was
Do
the
we know what early in the trial means? Do we know whether it was, do we even know that it was during the taking of testimony as opposed to some other part, voir dire, for example?
I don't know that we know explicitly. I guess I read into it the first day or two. I don't know that the witness said this happened on the first day of evidence. I think the testimony was this was early in trial. That's
And
about
then, as
good
you
I
said,
got.
the district court was there watching the witness testify. Isn't his ultimate holding, isn't there sort of an implicit credibility judgment in that holding?
I did not read any type of credibility judgment from the way the court ruled. What I read in the court's ruling was he didn't think it was enough, I guess. So I didn't think, and certainly the court didn't come out and say, as far as the witness that came forward, I don't believe your testimony. There was nothing explicit like that. And the way I read the ruling was the district court just did not feel there was enough evidence, but it's our position that certainly there was enough evidence through this witness and also testimony or the statement of the court reporter.
Before you sit down, Mr. Meharry, I'd like to ask you about the lesser included offenses and your position on page 19 of your brief seems to state that 215202 changes the landscape on how we look at factual determination, what supports the factual basis for giving a lesser included instruction.
Yes.
So it's your position essentially is if the state puts sufficient evidence out there for a jury to find a premeditated first-degree murder, it basically requires an instruction on all the lesser included instructions, at least as it pertains to the recklessness ones?
I believe it does.
And would you explain that to me? Especially in a case like this where the evidence isn't that this was reckless conduct, it was intentional conduct and shot at fairly close range, lay in wait for the victim to get there. How is this reckless?
As far, I guess,
And I know we have, it's reckless as opposed to the homicide, but how is it a reckless homicide?
as far as how is this reckless, I think there was testimony that would support a finding that this was reckless conduct, that my client's intent, depending on which witness you believe, was either to kill the victim in this case or to scare him, not having any intent to kill, but to scare him with a gun. The testimony was that he told one of the state's witnesses that he was going to shoot him in the butt. That's certainly reckless, that qualifies as reckless conduct. So I think there is evidence that this could be reckless conduct. As far as 5202 requiring reckless instructions when you have evidence supporting an intentional crime, when you read that, it says proof of a higher degree of culpability than that charge constitute proof of the culpability charged. If recklessness suffices to establish an element, that element is also established if a person acts knowingly or intentionally. That statute is saying that if you prove intentional, you've proven reckless. And
That's
I guess
not all it's saying, though. If I back you up to that language about the, can you just start again at the beginning? Proof of culpability higher
proof of a higher degree of culpability than that charged
than that
constitutes.
charged. And
Correct.
here he was charged with pre-med. Does that make a difference? Do we just read, doesn't your argument require us to read the two places that charged appears in the statute out of it?
Unless I don't have the whole statute in front of me, I only see charged once. And I think the second part, the second sentence, if recklessness suffices to establish an element, that element is also established if a person acts knowingly or intentionally. And I think if you just look at, say, well, if they prove reckless, have evidence of intentional, they're good, you're ignoring the second part of that sentence. And to me, it seems a little problematic that the state can charge somebody with reckless conduct, put on evidence of intentional conduct, and then argue that's sufficient. But that very same intentional conduct would not somehow be sufficient to give an instruction on reckless conduct. So it's sufficient evidence for the conviction, but it's not sufficient evidence for a lesser. And I don't think that is a proper way to read that statute. And what it requires, I think, is that when you have proven intentional, you give the reckless lesser as well.
All right. Thank you, counsel.
May it please the court, Cheryl Pierce, on behalf of the state. I guess I'll start with the prosecutorial misconduct issue with regard to statements that were made by the prosecutor during the trial. The first allegation is that the prosecutor said, "I don't think." And then there again, later in the same summation, he said, "I think again," with regard to the identification of the gun. What the case law tells us in this area is that you look at the entirety of the context of the statement, and you don't just get to pull one or two words out of the entire statement. As I noted in my brief, the prosecutor's statement was, "This seems to be the shotgun, folks. I don't think there's a lot of question about that at this point." He goes on at that point, and he talks about the .410 was found in the car. He talks about the .410 round that was found in the car of the defendant, and he talked about the gun being found in the Walnut River. He goes on to talk about the KBI test of the firearm, and he proceeds to talk about the rubber band that was described to be around the barrel of the gun and holding a .410 shotgun shell. Then he says, again, all of that is for your review.
Could he then go ahead and say, "I think the evidence shows this"?
I would suggest that he can't.
Didn't we say, I mean, the defendant has zeroed in on these problematic words, I think, and you recited all the context, which is prosecutor's discussion of the evidence. But does that actually change the character of the problematic, I think?
Well, I think what we get into, and there I said it, what the courts have found is that what's problematic for prosecutors and where we get in trouble is when we actually make a statement about the credibilities of witnesses, the ultimate issue of guilt, and those kinds of things. Here he's just wrapping up his statement in his argument. I think we've shown it, folks, and this is how we've done it.
But we said a year before the prosecutor made this closing argument, a year before, in the Charles case, we told the state to stop saying, I think.
I agree.
And so it kind of takes away from that case law that you talked about with the context and all of that, because in this specific instance, we said, quit saying I think, because you're throwing your own individual credibility into your argument, and that's error, right?
I agree that there was the case that came out in which you were very sternly advising counsel not to say the word I think. We've all read it, and I agree with that. But we're not robots. And as we make through these arguments, sometimes we have things like verbal tics. We have things that are transition, time fillers, and those kinds of things. And it's not that it's an expression of our personal opinion that this is the gun. He said, all of this is subject to your review. So when you look at the entirety of the context, he's given them the opportunity and saying to them, this is the evidence that we've proven, this is the evidence that we've shown you, and review it.
It sounds like you're suggesting that this may have been a rather innocent mistake, if we want to call it a mistake. In other words, not intentional, it wasn't intended to sort of be poor play by the prosecutor. But we've recently said that the prosecutor's intent is really irrelevant. And if you've got the pretty black letter case law saying, as Justice Bowles said, don't say I think, isn't it just error, and then you can argue whether it's reversible or not?
Well, that would be the next step. If you concede that it is error, and I'm not going to concede that it's error.
But let's do that. If you're not going to concede that it's not error, then does that mean we have to overrule the Charles case from 2016 so that we don't find error?
Well, if you find error, and then you go to the second prong of it, and was it prejudicial?
I understand that, but do we have to? Do you want us to? Are you arguing that we should overrule the Charles case?
No.
Then don't we have to find error?
I think you only have to find error if you don't find that it is not, or that it's an expression of his opinion as to the evidence. If you find that it's a verbal tic, or it's something other than a personal expression about the identification of the gun, then you don't have to overturn Charles. And that would be my argument. This is not an expression that this is the gun. The context of the statement is, here's the evidence, review it.
So we should parse which prosecutors have a verbal tic and which don't? I'm struggling with this.
I understand that, but I don't think that every time a prosecutor says, I think, that that's a personal opinion that persuades all of the jurors. You are obviously not persuaded by my argument.
What troubles me more than thinking that this court could maybe sort that out is how a juror is supposed to sort that out. If a juror hears the prosecutor saying, I think X, Y, and Z, that juror is probably going to assume that we are now hearing that prosecutor's personal opinion.
There again, when we look at all of the instructions, there is an instruction that clearly tells a juror that that portion of the argument or that portion of the trial is argument, and it's not the law. So I'm not so sure that the jurors can't rectify that when that's what they know that you are doing at that particular time. You're arguing your case before the juror. You're not stating the law.
But isn't that the problem, is that whether you use the phrase "I think" or not, if the prosecutor had said, "I don't think there's a lot of question about it at this point," and just flat said that, isn't the problem that the prosecutor isn't saying, "I submit to you," or "my argument to you is this is what the evidence shows"? It's a flat statement, whether you use "I think" or not. That's really not the problem. Isn't the problem the fact that the prosecutor didn't make clear that this is my argument, this is what I argue the evidence shows, rather than saying this is the evidence?
Well, I don't believe that just saying I think or I don't think in this context in its entirety is what you're suggesting is that that's his opinion, because he clarifies it and he says it's up to you. Here it is, subject to your review. He's given them the direction that you decide. It's up for your review. And when you look at it in the totality of the statement, I think the little "I think" at the end was not a personal expression.
Counsel, we've spent 9 minutes on whether that statement was an error. So let me move to the second part of the equation, which is, as I ask your opposing counsel, assume that it is error, so what?
That gets us to the second prong of whether it's prejudiced of the defendant's due process rights to a fair trial and whether it's harmless.
And his response to my question was, well, you had witnesses who changed their version of what had happened over time. Can you address that particular point?
Yes, I can. That's true. There were witnesses that did, in fact, change their stories over time, and the jury were well aware of that. There was testimony about that, and they weighed that evidence and determined who was credible and who wasn't. And so then it becomes, can the state demonstrate beyond a reasonable doubt that the error affected the outcome of the trial? And in this case, I would suggest and argue that it didn't. If you find that it was error for the prosecutor to say, "I think," was it harmless? Yes, it was. The evidence against Mr. Pruitt was overwhelming. The gentleman who drove him to the location testified about driving him to the location. He testified about pleading with him not to get out, not to go to the trailer, to the front of the trailer, not to take the gun. And Mr. Pruitt went anyway. Mr. Pruitt got out of the vehicle. The driver or passenger of the vehicle, Mr. Ralph Ballinger, ran away. He went around the back of the trailer, hiding in the darkness, in the bushes. And as Mr. Little came out of the trailer, the door opened, Mr. Little exited, and as he did, Mr. Pruitt fired and shot and killed Mr. Little. He then goes home and he tells his roommate, who was his former son-in-law, "I shot him." Hide the gun, and hid the gun. Then he goes back and the gun is retrieved by Mr. Jacob and hid again and discarded into the Walnut River. All that testimony came in. As far as the gun itself, it was a .410 shotgun. And although the absolute definite description of the gun varied, they all indicated that it was a .410 shotgun. It was. And that it had a rubber band that held a shell on it. That shell, with that rubber band, was still intact for the most part when it was retrieved from the water at the Walnut River. That shell was similar to the shell that was found in the defendant's car. It was also had a triple-aught buckshot. It had 3 projectiles inside the shell, and those projectiles inside the shell that was found on the gun in the car were similar to the projectiles that were recovered from Mr. Little's body. So you had all that information before the jury. That's overwhelming information that he had the gun. It was in his possession. It was the same type of gun that was recovered from the river, or it was the gun that was recovered from the Walnut River. And the bullet and the shell, the projectiles that were recovered from Mr. Little's body were the same of those that were recovered from his car as well as from the river. So the evidence against Mr. Pruitt was overwhelming.
You also had the testimony about the hit and the phone call
Yes,
and all that.
we did.
So an overall guilt, not apart from the gun, you had a lot of other evidence.
Yes.
I have a quick question.
Okay.
The gentleman who drove him to the site
Yes.
could not see the crime occur, right? He ran away when he heard the shot.
That's correct.
Okay. Is there any testimony in the record to tell us how long it was from the time the defendant left the car till the time that person heard the shot?
Not that I recall. As I recall, when Mr. Pruitt got out of the car, the gentleman that drove, Mr. Ballinger, was already beginning to flee.
Okay. As soon as he saw trouble on the
soon-
horizon?
right,
Okay, I thought he
because
waited till the shot. That's not right.
He saw Mr. Pruitt with the gun as he got out. He lifted up the gun. Mr. Ballinger saw the gun. He had already had this discussion with him, and Mr. Ballinger fled
At that point.
as the defendant was
Okay,
going
so we
up
don't
to
have
the car.
testimony about the amount of time?
No,
Okay, thank you.
no.
Counsel, before you're out of time, real quickly turning to the instructional error claim. In your view, would the evidence that came forward in the case have been sufficient to convict the defendant of reckless second-degree murder?
No, it was intentional, and I think the
Well,
evidence,
given the statutory language that your opponent pointed to that suggests evidence of the greater level of intent is sufficient to prove the lesser level, reckless, why wouldn't the evidence that came forward be sufficient if this was just purely a sufficiency question? Why wouldn't the evidence be sufficient to justify a conviction for reckless second-degree murder?
you would have had to ignore the intent behind what it was that Mr. Pruitt did to find reckless. I'm not suggesting that there's never a time that,
You're saying a reasonable juror wouldn't have gone there, but that's different from the legal question of whether the evidence is sufficient.
well, again, reckless behavior is very different than reckless behavior. Intentional behavior is purposeful, willful, gnawing, moving toward that direction.
I understand all that. I guess I'm asking you to address the legislative declaration that evidence of intent suffices to prove recklessness.
That I would agree with, because I think that lines up with what I noted in my brief as the skip rule. In what the skip rule says is that when there is a lesser included offense that's been the subject of an instruction, and the jury convicts of the greater offense, any error resulting from the failure to give that instruction, if still of a lesser included, is cured. So in this case, what was done was there was an instruction for premeditated first-degree murder and instruction for second-degree intentional murder. According to the skip rule, any of those others, because the jury convicted of the higher, the greater offense, all of those others are cured. If there was never any argument to suggest that this was a reckless act. At no time was there any information that this was a reckless act.
Well, I thought there was. I mean, it wasn't overwhelming evidence, but there was some evidence to suggest he didn't intend to kill Mr. Little, that he meant to scare him.
Well,
And to shoot him, I think, in the butt, for a lack of a better way to put it, but that's how it was. Several witnesses said that. And it's not whether you intended to shoot, it's whether you intended to kill that goes to the intent aspect and the reckless aspect of the crime.
Well, I would suggest to you that his saying that he intended to shoot him in the butt is rather self-serving, considering the fact that he took a gun and he hid in the dark. And he never said, there was no evidence that there was any conversation before. It was simply as Mr. Little walked out the door, he shot him. So I agree that that was some information, but whether or not it's valid, as I said, I think it's kind of self-serving.
Counsel, we've taken a lot of your time, and you are out of time. Would you like 30 seconds to wrap up? And at the end, tell us what it is you want us to do.
Well, I believe that the defendant's motion, or the defendant should be, I am sorry, I apologize. I would respectfully request that the court affirm the conviction of the defendant. I don't believe that there was any prosecutorial misconduct, and I also do not believe that there was any error by the district court in not giving a reckless second degree or a reckless voluntary. And as the other issues that we've not touched on today with regard to the jury nullification issue and or the motion for a new trial. And there was no cumulative error in this case, Your Honor. So that would be what I would request of the court today.
Thank you, counsel. And you reserve 3 minutes for rebuttal.
I guess just a couple quick comments, not to beat a dead horse as far as the I think, but the problem we see with it, and I think the problem this court has identified with the prosecutor saying I think, is that it is giving that personal opinion. It is giving the prosecutor's personal stamp of approval on that evidence. So in this case, when the prosecutor says, this seems to be the shotgun, folks, I don't think there's a lot of question about that. It's the prosecutor saying, look, trust me, this is the gun. And that is problematic for the defendant because it tilts the scale against him. The jury is no longer just weighing the evidence, but it's getting also the state's personal opinion on that evidence and consideration of that during deliberations. The other thing with regard to I think is when I reviewed the closing arguments, I saw it used twice. And that was with regard to the gun. He started out by saying, I don't think there's a lot of question about that at this point, as far as this being the gun. He closed, as the state pointed out, he said, again, all of this is for your review, but he immediately follows up, so if identification of the gun is an issue, I think that's been resolved. So it's not a verbal tick, it's a prosecutor giving his personal opinion on a specific piece of evidence. The other point I wanted to make and respond to Justice Steagle's question with regard to 5202, it seems to me if you read that statute, had the district court given an instruction on reckless conduct in this case, and the jury convicted of reckless conduct, 5202 says, state's good. that is sufficient evidence, even if it's all intentional, that is sufficient evidence to sustain that conviction. I don't see how that can be the case. The intentional conduct can sustain a conviction, but it's somehow not sufficient to support an instruction.
Would that be true even absent the evidence that you pointed out from the witnesses that said he only intended to scare Mr. Little? Let's just say that didn't happen. The instruction was given under your theory. There's no evidence to support anything other than an intentional killing. Would that be true, the sufficiency?
It seems to me, if they've proven intentional, they've proven reckless under that statute.
Just
And
as-
even if,
As a matter of law.
as a
So that's
matter
your
of law, the
argument.
legislature has said,
But you're reading that sentence, essentially you're reading it in complete isolation, and literally, which I understand, we've said plain language, but you're discounting the charged language in the previous sentence.
I guess if you just look at the charge, then it seems to me that you're ignoring the second sentence. So maybe the whole construction's a little mismatched, but when you read it, it says, if you've proven intentional, you've proven reckless.
At a minimum, it makes the statute ambiguous because of the conflict.
Arguably, it would make it ambiguous, and if it is ambiguous, I think this court should read it, the rule of lenity,
Apply the
laity,
rule of
whatever
lenity.
it's called,
Okay.
in favor of the defendant. With that, I would ask this court to reverse and remand this matter for a new trial.
Thank you, counsel. We thank both counsel for your arguments this evening. Court will take this matter under advisement.